SJC-11716, Commonwealth v. Craig McGhee.
Good morning. Elizabeth Dembitzer for Craig McGhee. The statute at issue in this case requires that the defendant act for the purpose of stealing from a bank. In this case, there was evidence that Mr. McGhee coerced two students, Fletcher and Brown, to get their own money from an ATM machine, and that he would take the money from them once they left the ATM machine. This evinces an intent to steal from Fletcher and Brown, but not an intent to steal from the ATM machine. To hold otherwise would be to stretch our understanding of the phrase "to steal from," well beyond its plain meaning. You can distinguish Mr. Brown's, and this I think you can see clearly when you look at what Mr. McGhee did not do. He did not coerce Fletcher and Brown to go into an ATM machine and break the ATM machine in intent to get the money out. He didn't ask them to unlawfully take from that ATM machine. He also didn't go to the ATM machine and take it himself. He waited until Fletcher and Brown were out of the ATM machine with their own money and took it from them. He intended.
So if somebody goes to a bank, to a teller, and puts the gun in front of him and says, "Please pull out all the money from your cash register and hand it to me," that would not be a crime against a depository because the money was handed to them by the teller and not taken from the till?
No, I think that would definitely be a crime. That's the standard crime of bank robbery, in a sense, is that you are illegally obtaining money from the purview of the bank. This is not what happened. This is for the same two reasons I said. One, the money was lawfully obtained through a withdrawal from an ATM, and two, the money wasn't coming directly from the bank. I mean, the money, when it was taken in an unlawful way, was in the care, custody, and protection, and the owners, Fletcher and Brown, and that's where the money was unlawfully taken.
So Justice Gantz's example could be tweaked a little bit so that, because the thing I'm having difficulty with is trying to put together the confining or putting the victim in fear with the purpose to steal from a bank. So there you have somebody who is going to the teller because they're afraid, because there's let's say a gun is pointed at them from across the bank by the defendant. And they go to the teller and say, "I want to clear out my account." And so how does that one work?
Well, I think that this statute is important. You have to look at it from the intent of the defendant. Is he intending to take the money from the teller? Is he intending to take the money from the individual? And I think that if he puts a gun, says, "Go into the bank and clear out your account and give it to me," and the person goes into their account, clears it out, and gives it to them, he's stolen from that person. He hasn't stolen from the bank.
Can you give me an example of a situation that would violate this statute?
I think there's lots of examples that would violate this statute. If he said anything that would evince an intent to steal from the bank.
Oh, but just give me an example.
Okay, the defendant walks up to a teller and puts a gun, and pulls out a gun and says, "Clean out this drawer." She's putting this person in fear for the purpose of taking the property of the bank. I mean, that's typically what...
That's a bank robbery.
Bank robbery, right.
That's what the statute is. I mean, the statute's for when people get caught.
So could you be convicted of this statute and armed robbery?
That's an interesting question. I mean, I think that it would involve, I mean, it's not the issue here. I think it would involve, I think, factually inconsistent conclusions. One is the intent from the bank, and one is the intent from stealing from the individual. Michigan has a very similar statute, and they have found that it's not a double jeopardy violation in that state to be convicted of both statute of armed robbery. I don't know.
So if you hold the gun and say, give me your password and your card, would that fit within the statute?
If you hold the gun and say, well, it would fit, that would very clearly fit within the second part of the statute, which the jury was not instructed on. And the fact that it fits so clearly in the second part of the statute, well, there's two sections to the statute. The first is confining or putting in fear for the purpose of stealing for a bank.
Yeah.
And the second part says, or surrender the means of opening any building, bank, safe, or vault. And that, the jury wasn't instructed on that section. And the fact that that example fits so perfectly in the second section tells me that the legislature didn't intend it to fit in the first section.
So,
I think the issue is, was the taking lawful at the time of the taking? Even if it's coerced, it still is a lawful. If the defendant, if they took out their money from the ATM and the defendant disappeared, was there a bank robbery then? It'd be very hard to say that there was. There's a distinction between lawfully taking the money from the ATM and not lawfully taking it. I think that's an important distinction, especially when you're talking about the defendant's intent.
Does it matter to you that this statute is under Chapter 265 rather than, I think it's 266? This is the crimes against the person. Does that figure into how it should be interpreted?
I think that it is providing a remedy for individuals who are held in fear or harmed when someone goes and rifles through the building or the bank where they are. So it is you mean because 265 is more against the person versus 266 property?
Right.
Yeah. So I think that it is providing a remedy for individuals who are caused to be in fear when someone is taking from the bank or building that they're in. So
Well, he's at the ATM machine, which is an extension of the bank.
yes,
So
but
what's the difference?
the difference is that the defendant's intent is not to steal from the bank, in the fact that he asked for the money to come out lawfully, though coerced, and in the fact that he waited until they left the bank and took it from them. That evinces an intent to steal from them, not from the ATM machine. If he said, go to that store, buy me 5 pairs of pants, come out here and I'm going to take them, under the same logic, you'd have to say he has an intent to steal from that store. That doesn't make sense.
In this statute, if a defendant were to be convicted under this first section of the statute, first part of the statute, it would have to be something like a defendant would walk into a small bank, tell the tellers to get into the vault, so he's confining them in the vault. He locks the vault and then goes up to their cash drawers and takes money out of the cash drawer. That would be a violation of this statute.
That's clearly a violation of the statute. The statute's been expanded to cover a building, so if a defendant walks into someone's house, ties someone up, puts them in fear, and takes money from their house, that's also a violation of the statute. It's been expanded outside of the bank realm, but it's typically, most of the cases, I believe, has been involved banks, depositories of money, where someone, you're punishing the individuals who are put in fear in the process of stealing from a bank.
Well, I guess if he has them drive to an ATM, and the whole purpose to go there is to get money out of that ATM, and the ATM fits within the definition of a building, bank, safe, etc. Why isn't that confining them and putting him in fear in order to take money out of that ATM?
Because it has to be an unlawful taking from the ATM. I don't think you can conflate his request for a lawful taking from the ATM with an unlawful taking from the ATM when you're talking about his intent.
Why not?
Because
He's confined. The intent is to confine someone and put them in fear for purposes of taking money out of a bank.
for purposes of
For
purposes of taking money out of a bank, but not for purposes of stealing money from the bank.
Well,
He's
you don't
stealing
have
from
to
them.
steal money from the bank, do you?
You do.
Oh, you
It's
do.
for the purposes
Okay.
of stealing from the bank. I mean, if Fletcher went and said to his friend, "Give me the $30 you owe me," and his friend gave him the $30, and he gave it to Mr. McGhee, it stretches our meaning to say Mr. McGhee stole from this friend. That's the same situation.
Well, okay.
Well, would you concede that your client may well be guilty under the second provision? Compels or attempts to compel any person to disclose or surrender the means of opening.
This language was in the indictment, but it wasn't charged, so I don't think it can be raised again. And I don't know, I didn't
There's
brief
no
it.
requirement that it be from the bank, just compelled to essentially surrender the means of opening any depository of money.
I think that if he
Values.
was, right, I think if he was to be convicted under any part of the statute, the second part is much more relevant. I mean, I think that you could perhaps construe it that by having them take their own money out, you are getting them to surrender the means of opening this for him. That makes more sense than having an intent to steal from the bank.
Could he have been charged with kidnapping for ransom?
He was charged with, well, he wasn't charged with kidnapping for ransom, he was charged with kidnapping.
Yeah, but for ransom?
No, he wasn't. I don't know that statute. He was charged with aggravated kidnapping for the purposes of a larceny. And that was, he was acquitted on that, and he was acquitted on the armed robbery. I think that my reading of the statute, the defendant's plain meaning of the statute is supported looking at other state cases, not these two federal cases, but I looked and searched for any time ATM duressed forced withdrawals, all over the country. Found about 170 cases, and as you would expect, they're all charged as robbery, mostly, unless there's some other crime involved. So it just reinforces when someone does this with an ATM that there's an intent to steal from that person, not from the institution itself, especially when the money's coming out lawfully.
Well, this wasn't raised in the motion for required finding of not guilty, so in a sense, the issue isn't preserved. Should we overlook that?
I think you have to overlook it. I think that I don't think you ever need to raise a sufficiency argument in a motion for a required finding. I think that it violates due process to be convicted when there's insufficient evidence, and that would be my answer.
If you could turn to the sleeping juror issue.
Right. So the sleeping juror issue, in this case, we are left with a serious doubt whether the juror was awake during substantial portions of the testimony. And I believe that this case is governed by the recent case in the appeals court, Commonwealth versus Gonzalez, by Commonwealth v. Braun, and by Commonwealth v. Dios. And those cases stand for the proposition that the trial court has an independent duty to investigate reliable reports of juror inattention, and that failure to conduct a voir dire when required is structural error and requires a new trial. And this is true even if counsel does not object. In this case, counsel did request a voir dire and then didn't object when the judge didn't decide to hold one. That's exactly what happened in Gonzalez. And in Dios, the defense counsel said, I don't want him as an alternate, keep him on the jury. And they still gave him a new trial.
Well, the defendant said, I'm good with it, right?
The defendant said, I'm good, and you will see elsewhere the defendant, it's in the record, the defendant has mental health issues, and the defendant's not the one who gets to decide these issues unless he's given, I would say, a knowing and voluntary waiver of them, and that certainly wasn't the case. It seemed like the judge in this case was interested in preserving juror. They were getting along. He asked the reporting juror, well, is it going to make you uncomfortable to be with the other juror? He'll know you told. And she said, it is a problem, but it's my ethical duty to do this. And then he said, okay, well, we're not going to rock the boat. And trial counsel at a certain point said something similar, like, we won't raise any red flags. Is that good?
So what are we to do about the fact that the judge himself said, I didn't see the person sleeping?
Well, at least in the appeals court.
How did the judge say that? Did he say it in the sense that, like the two lawyers did, I wasn't really focusing on the jurors, or did he say it, well, I was looking at the jury and I didn't see anybody sleeping?
No, he definitely did not make a conclusive finding that the juror was not sleeping. He said, yeah, that's what happened. When you're focused on other things, you really don't see it. He was not conclusive in that. I think that if the court finds that I don't think the court should find there's any waiver, because I think, as this court has said, or the appeals court has said, and this court has said, actually, this implicates the fundamental right to have an impartial jury decide the case. And as you know, the waiver of these basic constitutional rights that implicate fairness, need to be done
Well, that's been
knowing and waiver.
upheld in the courtroom closure cases, so why is this different?
I'll tell you. Got you. The courtroom closure case in LaChance, this court specifically said, the purpose of the Sixth Amendment guarantee of counsel is to ensure that a defendant has the assistance to justify reliance on the outcome of the proceeding. While a jury empanelment closed to spectators may be structural error, it will rarely have an effect on the judgment or undermine our reliance on the outcome of the proceeding. In Gray, this court said very clearly, the sleeping juror issue implicates the right to a fair trial. I think that's why it's different.
Thank you.
Thank you.
Good morning still. Assistant District Attorney Brett Dillon for the Commonwealth. I'm also the trial prosecutor in this matter. And so to address the first issue first.
If you could actually begin with the second issue.
Absolutely, Your Honor.
What was the judge's obligation when he had a juror who sat next to this juror say that she heard him snore?
I think the question becomes a matter of whether the judge abused his discretion in making the determination that he did. And his obligation is to determine whether he considers the information reliable, first of all, and whether the juror was asleep for what's considered a significant portion of the trial.
Because there was some debate, that what was the juror on this particular day? How much of the trial, as opposed to jury empanelment, went on?
I believe the record, it would indicate that the juror indicates that in her opinion, her fellow juror was sleeping throughout most of the morning. This jury wasn't sworn until after lunch.
Okay.
Evidence didn't begin until 2 o'clock.
And then when did it go till?
4 o'clock.
Is there any indication in the record that maybe the juror wasn't snoring but was breathing heavily because...
And that's an inquiry that the judge makes at some point. Basically, at sidebar with, I think it's juror number 6, there was a really decent back and forth where it's Judge Tucker, the Superior Court, essentially is asking whether or not the person could be closing his eyes, thinking hard. This juror in this case is very adamant that the person was sleeping, certainly, but what you have also is a situation where both myself, defense counsel, and the judge all are basically indicating we didn't hear that. This juror goes on to say it was incredibly loud and distracting. Again, all three individuals, the judge, the prosecutor whose desk is closest to the jury, and the defense counsel all indicated they did not hear or see anything like
Didn't the
that.
jurors say that there was another juror who had observed the same thing?
She did. Well, she said they may have, and that was never addressed. There was never a second indication where there was never a second conversation.
Was there
with the other juror.
any mention of this particular juror in the, what was it, 3-day trial?
I believe it was 3. I think it was 2 or 3 days.
Any other issue about this juror after that first day?
No, what I can tell the court is, and it's in the record, that at the end of this was brought up obviously in the middle of the trial. Most of the cases that defense counsel cites, actually every case, is brought up at the end of the trial. This is brought up in the middle of the trial where Judge Tucker makes it clear that his intention is to essentially watch this juror,
Right.
pay careful attention to see if he or she is paying attention.
So when was it? Was it at the end of the first afternoon or on the second day that this happened? That the juror came forward and this colloquy happened, or this conversation happened?
I believe it was the second day. I think it was brought to our attention that morning, if my memory serves me correctly. And that was when Judge Tucker basically indicated that he would watch closely. And as the record is clear, I frankly did the exact same thing. At the end of the trial, I brought to the attention of the judge on the record that I observed this particular juror and noted that this person was taking notes and appeared to be paying attention from what I observed after being brought that information to my attention.
But if the juror was asleep on day 1 and awake on day 2, he'd still get a new trial.
It depends on whether you believe the juror was in fact sleeping or not, I suppose. And technically, it depends on what was missed.
Wasn't that the issue here? I mean, we don't have findings by the judge, and the question is, what is a judge's obligation when he gets information that one would argue was reliable in order to make the findings as to whether or not the juror was asleep during an important part of the trial?
And the judge has to determine whether it is an important part of the trial. I think empanelment, frankly, may not be considered an important part of the trial for a juror's attention.
But I gather there's some dispute. I think your sister claims that he was asleep during the testimony of the 2 key victims, so of both victims.
If what juror, I think number 6 indicates, is to be believed and reliable, then yes. But the question becomes whether it's considered reliable and whether Judge Tucker abuses discretion regarding the nature of his intervention. And I think it's important. The timing in this case is I think particularly important. It's not a situation where in, I think it's Gonzalez, where it's brought to the court's attention a note while the jurors are deliberating. This is a situation where it's brought up midway through trial, and the judge has the opportunity to make his own observations, whether this juror is sleeping or not.
Do you make a waiver argument?
I don't. Ultimately, I think I frankly agree with Ms. Dembitzer on that situation, where I think a defendant is entitled to a
That's
fair
still, I mean,
trial.
but structural error can be waived, and I'm just wondering if you are making a waiver.
I'm not making the argument today, no.
Is there any legal and factual possibility that this case could be remanded for a hearing and the juror brought in?
That I don't know about, Your Honor. I mean, that's an interesting question. I don't know if years later that juror would have any.
When was this tried? What year?
This trial was tried, I believe, in 2012, I think, if I'm correct. And so whether that juror is going to remember what they had for breakfast that particular day, let alone several years ago, I don't know the answer to that. But I think realistically, in the situation at hand, what you have is a juror who certainly gives a very detailed description of what, in her opinion, is someone sleeping. And what you have, though, is what I would suggest is some contradictory information brought to the judge's attention from not only the prosecutor in the case, who was sitting directly next to the jury box, but also you don't have a clerk saying, in some cases, I believe it's a clerk brought to the judge's attention, this person was sleeping. Court officers are sitting next to these people, they could have pointed it out. You certainly have one person bringing something to the judge's attention.
How far away was it juror number 6 who reported this? How
Yes.
far away was that person sitting from the juror who was sleeping, so allegedly sleeping?
I believe they're directly next to each other.
Right next to one another?
Yes.
And how close to the prosecutor or to anyone else?
From the prosecutor, I can say in that particular courtroom, it's probably less than 10 feet.
Was this is this a front row?
Juror 6 would be in the back row, but in this particular courtroom, the tables are set up where the prosecution's table is essentially directly next to the jury box.
This is in Worcester Superior Court?
Yes, it is. And so,
The old one?
no, the new one.
What about the other juror who reported something about this?
I don't think another juror reported. I think what happened is juror number 7 indicated on the record that, or juror number 6, I think indicated juror number 7 was also may have heard something, and no inquiry was required or requested of that particular juror.
So the number that you're talking about is the seat number?
Yes.
What was the seat number for the allegedly sleeping juror?
His jury number, I think I'm going by jury numbers, Your Honor. Number 44 was a juror who was alleged to have been sleeping. Juror number 6 was the person who reported it. And juror number 7 was the juror, I believe, juror number 6 was reporting, may have also heard something as well.
But these were all people sitting in the back row
They were sitting in the jury box,
of the jury box?
yes. And so I think
They
ultimately,
weren't exactly right next to you.
they were about as far away as Your Honor is. And so ultimately, I think when it comes down to the simple question is whether the information was reliable and whether Judge Tucker abused his discretion in essentially holding off on a voir dire and simply just taking the time to carefully observe this juror, which indicated he would. And on the record, I think he makes it very clear that his intention was to watch, and if anything steps out at all, anything jumps out at him that this juror is not paying attention, he would intervene right then and there. And in fact, he didn't at all.
So you're not making a waiver argument, but do you suggest that it's irrelevant that the defense counsel and the defendant said that that procedure the judge was proposing was fine with him?
It's not that I don't think it's irrelevant. I think it certainly goes to the weight of the Commonwealth's argument, that obviously is a situation where defense counsel and defendant didn't notice this individual sleeping and made no observations of it whatsoever. So I think ultimately, in the grand scheme of things, you have one person versus 3 or 4 people who said they didn't see it, and a judge who has his discretion.
Or hear it, as it were.
Hear it, yes, certainly. Or at some point, they talked about someone's bad breath when they woke up, but I don't know.
Help me understand, others can go back to the sleeping juror issue, but I want to make sure I understand why it is that the Commonwealth abandoned the second theory under Section 21, which would have permitted a guilty finding based on the coercion of the information necessary to make the withdrawal from the ATM machine.
Because in my estimation, I'm the one who made that decision, is that the evidence was more than sufficient and more than strong on the first element of the statute, where what you have by way of facts is very simply a man forcing 3 young men into a car, their own car, driving them to an ATM. And I'll take issue with we've been talking about a bank, for instance, the entire morning. The statute's clear, it doesn't have to be a bank. The cases are clear.
No, but that's not Yes,
So-
but the argument is rather that the stealing was from the individuals, not from the ATM.
Certainly, and I think ultimately, to call it a lawful taking, I think, is a stretch to begin with, when what you have is 3 individuals forced against their will to drive to the city of Worcester, stop at an ATM, forced out of a car keys in hand from the defendant and cell phone in hand from the defendant, forced into an ATM and told to take out money.
From their own accounts.
Certainly, but I mean, it's a situation where, and what you have is on top of it, the secondary argument being that one of these young men,
But that wasn't the bank's money, right? You'll acknowledge that.
yes, it came out of their account, certainly, but what you have here is it's a somewhat odd situation where these individuals didn't go to their particular bank. If I'm a Bank of America customer and I go to Bank of America, that account is coming out of my account. These individuals had different bank accounts. Their statements were marked as exhibits, and they took money out of I think it was a Bank of America account that wasn't their account at all. But is it their money? Yes. Do I think it rises and falls on that issue? I don't. I think ultimately,
Well, I don't think I got an answer to my question, and it's really important that I get an answer.
yes.
Why the Commonwealth abandoned this theory?
Because on the strength of the facts alone that I had presented to me, I didn't think I needed to go on a secondary theory at all. I think ultimately the defendant's actions, and a jury agreed, met that first half of the statute, that he put them in fear. There's no question about that. I don't think it's even an issue. 2, that it was to commit a larceny. And 3, that the money was taken from a building.
So your argument is that this doesn't have to be the property of the building.
No,
it
and I
just has to be taken from a building.
And we're discussing,
It's property of anybody. It could
yes,
be.
we're talking about Chapter 265, which involves victims. To say an ATM machine can be a victim, I think, is a bit of a stretch. I think we're here to discuss the human aspects of the case, where these 2 young men were clearly the victims, clearly the intended victims. They were placed in a building and had money stolen from them. Whether they took the money out themselves is, I think, as one of the federal cases cited, they essentially acted as an arm of the defendant, doing his will, taking the money out at his request. Had they...
Yeah, but if, assuming this was an FDIC bank, the defendant got away with this money and spent it, could the bank have recovered the money?
I think, well, they've been insured. Certainly, I think they would have recovered it.
Really?
Yes, and that'd be my guess. But what I think here is, importantly, is a situation where...
Were the feds notified?
No, typically not. In bank robberies, they generally stay in the state courts. And this, it wasn't certainly charged with an armed robbery. There's no state bank robbery statute, obviously. What we have is confining to commit a felony, and on its very simplest terms...
Well, wasn't he charged also with armed robbery?
Well, he was, and he was acquitted.
Yeah, I understand that.
Yes. So he's charged with that, and that's a separate crime. I know there's an issue whether he could be convicted of both, and he could.
But, so, I'm back to Justice Hines' question. I understand you think it was clear, but why wouldn't you, I'm still, is it a lesser sentence? I mean...
No, I mean, if you ask me now, a few years later, would I have done it differently? Yes. I mean, to be quite honest with the court, I probably wouldn't have limited the argument, but ultimately, viewing the case as what it was, I felt very confident in the facts of the case being that individual was placed in fear for the purpose of larceny, and the larceny was committed in a building. And so I didn't necessarily think making a secondary argument about forcing them to use their PIN was necessary at that time.
So ATM is a depository of money.
Yes.
Is that correct?
Yes.
And so they were confined or threatened for the purpose of stealing from that depository of money.
Yes.
And it doesn't matter whose money it is.
I
It's
don't-
stolen from the depository. Is that your argument?
Yes, I agree with that, and I think that's exactly what the statute is designed to prevent, and that's exactly what happened in this case. There's no further questions. I would rest on Ms. Herron's brief.
All right, thank you.
Thank you.